Hi all, thanks for joining us. Disability Law Queensland have put together a webinar to discuss JP and CDEC obligations when witnessing documents for people with intellectual impairments. I hope you find it useful.
Today I'm really happy to be here to talk about a resource that we've developed that we use in our work to help people with intellectual impairments to understand what enduring powers of attorney are. I think it's really important to say at the beginning that this presentation and this resource is not a resource to help JPs and lawyers understand their obligations in witnessing documents, and it's not a resource to help attorneys to understand their obligations once they're appointed. This is a resource that should be used by JPs and lawyers understanding their obligations to assess capacity, but helping them and helping the person they're assisting to overcome barriers that might sometimes mean that people with intellectual impairments are not given the opportunity to develop the capacity to complete an enduring power of attorney. So really what we've developed is a resource that tries to assist people with intellectual impairments to understand what an enduring power of attorney is, and then to instruct a lawyer or a justice of the peace, someone witnessing the document, what they would like the document to contain. And as I said, in terms of what the witness's obligations are and what the process that the witness should follow, there are other resources that explain those things, and I will mention them at the end of my presentation. So today really what I wanted to focus on is obviously the resource. What is our resource? And so I'm going to give a little bit of an overview to that and then why we went about developing this type of resource, and also just to put it in context to explain how we developed the resource. Okay, so what we actually developed is a suite of 3 resources because it was both enduring powers of attorney and also wills that people with intellectual impairments were often wanting to have prepared and sometimes struggling to understand. So we have focused on trying to help people with intellectual impairments understand wills and enduring powers of attorney. And clearly our audience is clearly people with intellectual impairments or cognitive impairments, but interestingly these resources have also been used in other applications. So they could also be used where people don't have those impairments but perhaps have other challenges associated with English being their second language or poor literacy skills. We designed these resources thinking about supported decision making, so the idea that a person can be supported to make a decision, and so these documents are not designed to be used in isolation. They're designed to be used with a decision-making supporter, which basically means a person helping the person to develop the capacity. And in our experience, that person is often the parents or siblings, family members of the person with the intellectual impairment, but it could just as easily be a person like a service provider, a support worker, someone who's the important thing is that it's someone who's familiar with the person and used to communicating with the person, because we're really trying to leverage off that person's skills in being able to understand the person that's trying to develop the capacity. So in terms of the why, I guess we come from, I guess the first thing is to try and debunk the assumption that because you have an intellectual or cognitive impairment, it means that you can't have a will or you can't have an enduring power of attorney, which I'm confident that this audience would understand that it's not, we're not focused on a person's impairment, but we're focused on a person's capacity. And obviously, that also goes to the person's fundamental human rights. So the right to be treated equally with others, the right to have their own autonomy protected, and the right of an adult to make their own decisions to be preserved as much as possible. We're also concerned about the growing number of applications being made to QCAT for guardianship and administration orders for people with impaired decision-making capacity. And although it's clear that guardianship and administration orders are required in some circumstances, it's also clear that these orders should be made as a last resort, and that the adult's right to make their own decisions should be preserved as much as possible. And I guess when I say this, it's not, speaking from my own personal opinion, it's speaking as a reflection of what the law actually says. So, as many of you would be aware, an administration order is an order where the Queensland Civil and Administration Tribunal removes an adult's right to make their own decisions and gives those rights to somebody else. And so for an administration order, they're appointing someone other than the person with the impaired decision-making capacity to make financial decisions for them and about them. And when it's a guardianship order, it's the non-financial decisions. There is some misunderstanding in the community about when these orders are appropriate. And so many people, including parents who have children with impaired decision-making capacity, think that when their child turns 18, that means that they need to go and seek an order. But if you actually look at what's required in the Act, the impaired capacity is only one limb of the test. So, if you go to the tribunal seeking a guardianship administration order, the first thing you need to prove is that the adult has impaired capacity. And in this context, when we say impaired capacity, we're looking at the adult's ability to understand the nature and effect of the decision, to be able to communicate it in some way, and to be able to do so freely and voluntarily. And when one of those limbs is missing, we can establish, and usually by medical evidence, that the person has impaired capacity. But that's not the only thing we need to prove when making an application to the tribunal. We also need to prove that a decision needs to be made, or that without the order, or that the person is likely to do something that places them at risk. And then the final limb is that without the appointment, the needs of the adult will not be adequately met, or their interests won't be protected. And so actually you can see in that test that if we're able to put other things in place to protect the person or to enable decisions to be made on their behalf when they can't make them, we certainly wouldn't need a formal order. The other thing about an enduring power of attorney as opposed to a formal administration or a guardianship order is that this puts the person in the centre of the arrangements for decision making for them. So it allows them to be the person who chooses who they want to make decisions for them, rather than having a tribunal make that decision for them. So unfortunately, I've been involved in quite a few contested guardianship matters, or where the tribunal has, for example, appointed the public trustee or the office or the office of the public guardian, in cases where perhaps the adult, given the choice, would have clearly chosen one of their family members. And so one of the benefits of this is it allows that person to have that choice. It also allows them, as this audience would appreciate, to have some choice about how those decisions are made. So we can have a conversation about whether there's any rules that you want your attorneys to abide by, and obviously those can be contained as a term in the document. So I guess, as I said, we really, the idea was really to try and develop the capacity of people with intellectual impairments by providing them with information in a way that they are more likely to understand it. So really clearly with that audience in mind, and also knowing what we do about this particular cohort of people is that often as they interact in the world, they will have an informal support person or people helping them to communicate and to make decisions. And we need to make sure that we're leveraging off that capacity to help people to form an understanding of what an enduring power of attorney is. So as I've said, in developing the resource, we made sure it was informed by research and practice around the country related to supported decision-making tools, supported decision-making, and tried to make sure that our resources reflected that research. We also did desktop research to look at existing resources explaining enduring powers of attorney and wills, and also considered existing resources related to the obligations of people witnessing documents and also the obligations of attorneys. And I guess really importantly, the other thing that we looked at, we pulled out all our old files where we had already done this type of work and reviewed them to use that as a basis, or our practice as a basis to inform these documents. So how we developed the resources is that we, based on that research that I've just sort of gone through, we then developed 3 resources. So the first resource is a guide for the supporter, so the person who's assisting the person with impaired decision-making capacity to understand a will and an enduring power of attorney. And then we developed one resource that explains what an enduring power of attorney is, and one resource that explains what a will is. We then took these resources to people with intellectual impairments and their families, and we asked them to use the documents, to look at the documents, to critique the documents and give the feedback to us. And we also got a lawyer in our team who wasn't at all involved in developing the resources to use the resources with clients and for her to give feedback as well. We incorporated that feedback, and we also went out to stakeholders and got and incorporated feedback from the Office of the Public Advocate, ADA Australia, Carers Queensland, and the Australian Centre for Health Law Research. So hopefully you will have received the documents. I think Belinda may have emailed a link to our web page that contains the documents where you can download them. So if we just look firstly at the document for the supporters. So as I said, this document is for, this is the purple document that we're looking at, and this is for the supporter. This is for the person who doesn't have an intellectual or cognitive impairment, who's going to help their family member or their friend or the person they're providing support to understand an enduring power of attorney. And if you go down, it explains the role of the supporter as someone who's facilitating the development of capacity, and making it clear that the supporter should always respect and value the adult's rights to make their own decision, avoid using their role as a way to advance their own or any other person's interests, and make sure that they're able to spend as much time as is required to support the person to understand what the document is, and to make their own decision about what they want their documents to contain. It explains to the person who's supporting someone to make a decision what the role of the lawyer is. But in this context, that could be, obviously, that would be the role of the person witnessing the document, and explaining, that the person witnessing the document has that legal obligation to ensure that the adult has the capacity, does understand the document, and that is the role of the witness. Then on page 5, it starts to talk about the process that should be followed. So really, in practice, what happens is we would suggest to the supporter that they take the resources away and use them with their adult to help them to understand what an enduring power of attorney is. I always think it's a really good thing to do to normalise the process, so that the person knows, hey, this isn't because I've got a disability, this is something that most people in the community actually do. And so the supporter might want to show the adult their own enduring power of attorney, or an example of an enduring power of attorney, to help them both understand the concept as something that's actually a practical document, but also so they realise that this isn't, they're not having to go through this just because they have a disability. So then usually what we would do is we would have an initial consultation with the person and do that sort of initial assessment of their capacity and their ability to make decisions without being influenced. My practice is not to require seeing the person by themselves, because my experience tells me that when a person is when they have their support person taken away, that actually diminishes their capacity. And as long as I'm comfortable that that supporter is not placing any pressure or influence over the person, I feel that it's more important to have that support person in the room. Sometimes, I guess, this is all up to your own judgment as a witness, but sometimes you might get the sense that the person is being influenced or isn't able to act without, it's really being goaded and guided by their supporter. And in those sort of situations, sometimes you can ask that the next time you see them, they bring a third party that potentially isn't going to be appointed. So that's the way I've gotten around it in the past. So I have that initial conversation or meeting with the client, and then following on. So then I guess in that initial consultation, we've got a really good opportunity to have an initial view of the person's ability to understand the documents. That's not the time where I will assess the person's capacity, but I will take detailed file notes about the person's capacity and my preliminary view of their capacity. I then seek some and this is going on to page 6 of the document, but I would then seek permission from the adult to write to their doctor. It could be their GP or another appropriate person about their opinion of the adult's capacity to understand the document. And so the client would then go away, take the letter to the doctor with them, and we'd wait for the medical report. If the medical report comes back and says no, the person doesn't have capacity, I would never proceed to finalise the document. If the doctor's report comes back and it's contrary to what my preliminary finding was, and by that I mean when I met the client, I felt that they understood, and then the doctor writes and says they don't understood, I might have a chat to the doctor and find out a bit more information about why they didn't think they understood and what the circumstances were, how the consultation went along, whether there was anything that kind of made it difficult for the person. And sometimes I've asked the doctor to see the client again. But unless I get a positive report at some stage from a doctor about confirming capacity, I wouldn't proceed to the final appointment, where at that final appointment I would meet with the client and the supporter, and then do that capacity test, and you'll see that that's outlined on page 6. So remember, this document is for the supporter, so it's helping the supporter to understand what the witness is actually looking for. And so sometimes people say, I believe my family member could understand what an enduring power of attorney is. And this document can help them to test that view. So we're not just talking about can they understand I'm choosing mum to help me with my money. That wouldn't be enough of an understanding, that it's a little more complex than that and more comprehensive. And so on this page, we help the supporter to understand what the witness is actually looking for. And we always, and then, if you're satisfied, if I'm satisfied that the person does understand, obviously we witness the document. And always, the other thing that I just always flag with supporters is that it's a good idea to talk to whoever's the witness, if it's a lawyer, about what their costs are going to be, because this process is obviously more involved than the usual process for witnessing an enduring power of attorney, so it's going to be more expensive. The other document that I just wanted to quickly have a look at is the actual resource that the supporter then uses with the person with impaired decision-making capacity to help them to understand the document. So as you flick through, you'll see that this document is really an easy English illustrated resource, helping considering those things that a person needs to understand in order to have capacity, and then trying to put that in really plain English. So, one of the ideas was this idea of a stamp, that an enduring power of attorney is giving someone your special seal of approval. So you're choosing someone. And as you'll see, if you go to page, start going down to page 4, we start to think about who we trust. And you'll see we're asking for names, addresses and phone numbers, because this can then be used directly, put into the enduring power of attorney, and people can either complete these resources electronically, or they can also complete them by with a hard copy as well. Going through the document, page 5, explaining exactly what decisions are. So financial decisions are about your money, and when I talk to people about that, we talk about, well, what is money, and do you have some bank accounts, and who helps you with those? And then we talk about other things like, what does health mean? Means going to the doctor, means whether I need to take medicine. Personal decisions might be about what I want to do with my time, what I want to eat, and what support I need. Can also be things like whether I have a job, those sorts of things. On page 6, we just try and encourage people to think about some of the decisions that someone helps people with at the moment, because even that concept of decisions can be confusing at first. And so when the supporter is asking this question, they're probably then giving the person examples of, well, you know, when mum goes into the bank with you and we withdraw $50 for your spending money, you know, that's me helping you to make decisions about how to use your money. And then we have this question: do you want to tell your attorney that they may need need to talk to you about the decisions that they're making for you? So this, I guess, is an opportunity if the person themselves wants to always have the ability to feed into decisions. They can put this term or condition in the document. There's sort of two ways of thinking about this. On the one hand, it does sort of hardwire the person's involvement in all decisions. On the other side of things, it can actually make things more complicated, because when the document's used, say, at the bank or something like that, and the bank sees that term in there, then they won't allow the attorney to make the decision unless they've got evidence that the principal consented to it. And so it can actually fetter the process a little bit. So I just also be careful with that, with adding those conditions. And you'll see as you go through, you know, that each section really reflects what the person needs to understand in order to have the document prepared. So in relation to financial decisions, usually we'd be looking for the appointment to start immediately, because often this group of people that we're working with have real issues managing their own money, and so they really do need assistance right from the get-go with the financial decisions. So there, I think that the main things that I wanted to highlight in the documents. The final thing that I think is really, and I know I've sort of laboured this point, but it's that this resource these resources that I've gone through with you this morning are not supposed to be a document to help you to assess capacity, in the sense that it is not about helping you understand your obligations, and it is not about helping an attorney to understand their obligations. There's some fabulous resources that do those things. Yeah, and so I'm sure many of you would have already looked at these documents and referred to them, but the Office of the Public Guardian has a great document, Guidelines for Witnessing Enduring Documents. Queensland Advocacy Incorporated's Queensland Handbook for Practitioners on Legal Capacity is an absolutely fabulous guide to help you to understand what your obligations are in terms of assessing capacity. And the thing I love about that resource is it's really trying to, just like these resources, help practitioners walk that line of making sure they're covering off on their own legal obligations, but also making sure that they're giving people with disabilities as much opportunity as possible to have access to these types of documents. Also, and I'm sure many of you would have seen these, ADA has developed resources to assist attorneys to understand their obligations and responsibilities, and that includes some video content which is really accessible, and I'm sure would be a great resource for you to point attorneys to if questions are being asked about, well, what's actually their obligation and responsibilities once they're appointed. That's you've all been given the correct URL to, because it's been updated since I developed this presentation, but you've all been given the correct URL where to get the resources. As is obvious, they're free resources. Really happy for you to use them and share them in any way that you can. That's probably all I really needed to say about the documents. If you ever wanted to get in contact to ask questions, my contact details are also at the end of the slides. Is there any questions coming through there? No questions.
But we'll leave the Q&A open for a few minutes if anyone has any questions. It's been very interesting to hear about the service that you provide and how you do that. So I think if we don't get any questions, we might take this off. So I've got one question. Was the JP branch part of the consultation process when the documents were being prepared?
That is a good question, and I'll have to take that on notice because the documents were developed about 2 years ago and I cannot remember exactly everyone we sent them to for feedback. The organisations that actually provided their feedback were those ones that I mentioned, but we did actually send it out to other stakeholders that weren't able to provide any feedback, but I can find that out.
Carmel's just asked a question. Carmel, I'm not quite sure that you've completed the question. If you're able to sort of review what you've typed and put it in again, that would be great. Just wait for it to.
Yeah, and that's fantastic. I mean, if so Disability Law Queensland does not receive any government funding, and so we do charge fees. And one of the reasons that I wanted to present to JPs today is to give you an opportunity to think about providing these services, to have confidence in providing these services to people with intellectual impairments, because it means that people that can't pay fees could also have access to this service. So, you know, I fully acknowledge the great work that JPs do and hope that this can be a resource that helps people access those free services. In terms of providing, so I've just been asked the question, are JPs encouraged to provide feedback on your documents? I'm happy to have feedback. Unfortunately, we wouldn't have at this stage capacity to make significant changes to them, given that we received a grant to produce them, and we don't, as I said, we don't receive government funding, and so any significant review of the document would need to be accompanied by some funding.
What safety measures do we have JPs have to determine that the person is capable?
Okay, so one of, I guess, you know, there's two things. One, always when witnessing documents, you would have to use your judgment. And so you need to be satisfied that the person understands the document. So that's the first thing. If you have formed that view, you should be taking detailed notes of why you formed that view. I have suggested that you would see the person on 2 separate occasions, and that during those conversations you would make notes of, or following those conversations, you'd make notes of why you thought that person understood and how they communicated that. The other really essential thing, as I noted, was I would never complete one of these documents without some medical evidence that backed up my view that the person had capacity. So if it was ever challenged, I can produce 2 detailed file notes of 2 separate occasions where I met with the person, and also some independent medical evidence that supports my own view that the person had capacity. For an enduring power of attorney, that's not one of the parts of assessing someone's capacity, but certainly for assessing someone's capacity to have a will, they do need to have an understanding of the assets that they own. And the law clearly says a general awareness of the assets that they own. And so it's not that they need to understand exactly what they own, but something like, I have some bank accounts, and they've got some money in them. I may or may, I own a house or I don't own a house. I own a car or I don't own a car. So a general awareness. What the law says is that the more complex the will is, the greater level of capacity a person needs to have. So if we're talking about a pretty simple will, we need someone just to have that general awareness of the property that they own. And yeah, they do need to communicate to us that they have an understanding of what they own. And in order to do that, they will need to tell us in a general sense what they own.
So Michael's asked a question, if the principal needing an EPA comes before us, is there documentation they can produce so we know they have a disability?
So I don't think that that's the relevant factor here. So we're not, you would all know that when we first see a person seeking to have an enduring power of attorney prepared, we have an obligation as witnesses to make sure that person has capacity. Now, many of you would have had the experience of having a conversation and starting to doubt that the person has capacity. And sometimes that's from, because the person's older and has dementia. I've had cases where it's clearly related to mental illness, or also it could be related to an intellectual impairment. So rather than us asking for a client to present information about their disability, where it's on us to, if we're doubting capacity, to then go and seek some medical information about the person's capacity.
I think that's all questions. So we might just give it just another moment, just in case somebody is badly typing away. Okay. If the person is on a disability pension, how often would a person not be under a carer?
Look, so I guess that question is if a person's on a pension. I mean, I'm not really sure how that's related to this, other than to say that obviously a person with an intellectual impairment cannot appoint a paid service provider as their attorney, but if someone's on the carer's allowance or carer's payment, that would not preclude them. It's only where they're actually a paid service provider.
If a profoundly intellectually disabled person that does not have the capacity is the only option, guardianship?
No. No. So that's a great question. So when we talked before about that process, so I would usually divide it in 3 groups. So the first would be the person has an intellectual impairment, but with these resources and with support, they can understand an enduring power of attorney. So that's one group. And then there's like a group of people that have intellectual impairments that can't understand what an enduring power of attorney is. And so what we then do is we look at how are you currently supporting the person to make decisions, because informal supported decision making and informal substituted decision making is actually recognised in the Guardianship and Administration Act. It clearly says that people can be informally supported to make their own decisions. They don't need to have a formal order. So, with Centrelink, there's a nominee system. You don't need a formal order to act for someone when talking to Centrelink. The NDIA also has a nominee system. Most service providers acknowledge the informal role of the informal decision-making authority of close family and friends. When it comes to health, there's the statutory health attorney regime that you would all be familiar with. So we look at the different aspects of the person's life, and we make sure that without the order, the person's needs and interests can still be met. And that's compatible with those tests that I went through for seeking a guardianship administration order. Then if it's the case that the informal processes aren't working, then that would be the situation where you would need to go to QCAT for a formal guardianship and administration order. You don't have to get both a guardianship and administration order. So the administration order is about finances. So sometimes just an administration order is all that's required. The guardianship order is the non-financial things. Situations where it's clear that an order is required is often things like where there's serious conflict in the family. So it's not clear who the informal decision maker is and the person's needs and interests aren't met at all because of the conflict within the family. Or it could be some of those really, black and white legal things, like if someone was trying to buy a house in the name of their person who has impaired capacity, yes, we would need a formal order in place. But you'd still be asking the question before that, should the property really be in that person's name, or is there a different way to go about it? So should a trust be established to own the property, or is it better off to keep it in mum and dad's name? So I guess the short answer, as opposed to my long answer, is no. We first of all look at how we can informally support someone. It's only when those informal processes don't work that we would then say that an administration order is required.
By asking questions based around the first 6 pages of an EPA can help to determine the capacity. That's right. That's from Janice.
Yeah, that's right. Yeah,
that's exactly right. Good pickup. Right, well, I think we might take a moment now to thank you, Amy, for coming along, and to all of the JPs and CDECs and participants of the webinar. Thank you very much for taking time out of your day. You have the, if you still have any questions that haven't been answered, or you would like us to put you in touch with Amy, or vice versa, we can certainly do that if you have any more questions that weren't able to be answered today. But one of the things that you can also do is share those resources that we did email out to you if you would like to do that. But thanks, Amy, very much for coming along today. I'm sure we've all learned a little bit more about assisting somebody to have an enduring document created. So
it was a pleasure, and thank you all for attending.
Thanks for tuning in. I hope you enjoyed the course, and we look forward to bringing you more online professional development training in the near future. Thank you for your continued work in serving the community of Queensland. We'd love to receive your feedback on this webinar. You can email us at jpsinthecommunity@justice.qld.gov.au.